is Stephen David. I'm a member of your Indiana Supreme Court. And before I introduce the task force members and we officially get this meeting started, I would invite the Chief Justice of Indiana, Loretta Rush, to come forward. She has a few remarks that she would like to make to everyone gathered and everyone listening. So, Chief, have my seat. And
I can just stand. Thank you. Well, thank you all for coming down here. I love doing this in association with the Indiana Association of Cities and Counties. You've been a wonderful partner in looking at jail overcrowding. It's an issue that hits all of us. I'm just here mainly to introduce Justice David, who I, as being legislatively tasked with this, or my designee, I've asked him if he would serve as my designee, and he will be introducing the rest of the task force. Some introduction on Justice David. Justice David has chaired the initiatives that sort of dovetail into this. He's been our go-to person on pretrial. He'll probably talk about a summit that we're having statewide this week, the evidence-based decision-making. He has 28 years military experience. He was a colonel in the military. He was chief defense counsel in Guantanamo Bay while he was a judge in Boone County. He took that. He's won Citizen of the Year, Judge of the Year. He has a passion for this topic, strong leadership ability, and he will be chairing this group, listening to you, and there will be a report done at the end. So just know you've got a champion on this issue that's chairing this. At this time, I turn it over to Justice David. Justice David.
Thank you, Chief.
Thank you.
If I had known what you were going to say, I probably would have not let you do that. And I didn't realize I've died. That was a very nice obituary. But thank you. Thank you. And thank you to the task force that has been put together and for the legislation supporting this. At this time, I'd like to introduce the task force members. First of all, Representative Greg Sturwald from House District 40. He's the co-vice chair. Representative Reagan Hatcher from Indiana House District 3. She's unable to be with us today, but if you're watching, ma'am, good afternoon. Senator Mike Gaskill, co-vice chair, Indiana Senate District 26. Senator J.D. Ford, Indiana Senate District 29. Tracy Brown, Tippecanoe County Commissioner. Doug Huntsinger with the Office of the Governor. If you all want to raise your hand or jump up and down, you're more than welcome to do that. Make sure everybody can put eyes on you. Ralph Watson, Indiana Association of Community Corrections Act Counties. Commissioner Robert Carter, Indiana Department of Correction. Mr. David Powell, Indiana Prosecuting Attorneys Council. Bernice Corley, Indiana Public Defender Council. Sheriff Brett Clark, Hendricks County, and a member of the Indiana Sheriff's Association. We have also at the table in front of you is Justice Christopher Goff, member of the Indiana Supreme Court. And Justice Goff and I are helping to assist in this endeavor. And those are your committee members. The purpose of this task force is really very simple, yet extremely complex. Our charge, our legislative charge, is to conduct a statewide review of jail overcrowding, to identify common reasons for that and possible solutions, as well as study ways to reduce recidivism for those in jail by offering additional programs or what programs are working, what services are working. We are to gather facts, hear testimony, digest that testimony, and submit recommendations to the General Assembly so that they can take appropriate steps. We hope to hear diverse opinions in an undivisive way during this process. We look forward to hearing from not only our presenters, but those that are members of the public that would like to testify. Thank you for taking the time to attend today. We'll be receiving some presentations, actually 3 today. Each of those presentations will be approximately 30 minutes in length, following some opening remarks by a couple of key individuals, and then we'll take public testimony. Relating to jail overcrowding, The task force information can be found online. I won't endeavor to give you that website, but it's readily available now. And you can go on that website and you can submit any comments that you would like, and they'll be considered by this task force. Submit whatever information you would like for the task force to consider. In addition, you can go on that website. Those of you that are watching this webcast, go on the website and learn where we're going for the second and third meeting, and you can actually go online and sign up to provide some public testimony. The committee has asked that anyone providing public testimony limit their testimony to 3 minutes. But again, anyone, and we mean anyone, can post their comments directly to the website so that everyone in the state of Indiana has an opportunity to inform this group, who then has the obligation to make recommendations to the General Assembly. So again, thank you for being here. Before we begin taking our first presentation, the committee has asked that a couple of people provide some opening comments. And first, I would invite Sheriff Brett Clark, Hendricks County Sheriff, and the Indiana Sheriff's Association representative on the task force to make some opening comments. So, Sheriff?
Thank you, Judge. Folks, on behalf of your 92 Indiana Sheriffs and our Indiana Sheriff's Association, I also would like to extend our thanks to you for taking the time to join us for this important day. It would be simple and easy to assume that this is simply a sheriff's problem or a commissioner's problem, because after all, it deals with our local jails. But at the end of the day, it's a community problem. So my ask would be that you come to the table with an open mind and in the spirit of cooperation, realizing that for Indiana to continue to be a leader as we are in so many other areas, it will take input and synergism from everybody involved. So again, thank you for taking the time, and all of us here on the committee and the sheriffs, I'm sure, look forward to the conversation.
Thank you, Sheriff. And we can't underscore enough, this is an initiative that essentially asks every Hoosier to help us solve these challenges. I don't think you would find an initiative quite like this anywhere in the state of Indiana. And for a little background on this initiative and the reason we're here, we're going to ask Representative Randy Fry, House District 67, to share a little bit of the history behind the Jail Overcrowding Task Force. Sir?
Thank you, Your Honor, and members of the task force. During the 2019 legislative session, I was honored to author House Bill 1065, which did pass with overwhelming support of the House and the Senate, creating this task force. The idea came after talking to many of my counties. I represent 7, all are part of 7 counties in southeast Indiana, and all of my counties, in one way or the other, are struggling with crowded jails. And so each of us were looking to, what's the solution? Do we build new jails? Do we build bigger jails? What do we do? And so working with my colleague, Representative Sturwald, and Chief Justice Rush, thank you, and you, Justice David, we began to look at possibilities of why these jails are overcrowded. Is it because we need bigger jails, and that may be the case, or is it because there are other issues that we could be addressing, such as bail? Representative Sturwald and I had many conversations about this particular subject, but if someone is stupid tonight and they get arrested, 2 individuals, same kind of crime, no violence, no weapon, and the bail set, say for instance, $600. If I have the bail money, I get to go home. And if I don't have the bail money, I may be incarcerated for an extended period of time, maybe 30 days, maybe 60 days. So what we found was, based on your social economic status, you can either go home and keep your job and keep your credit and keep your car and keep your house and keep your family together, or you can lose it all, and at the end of the time you're before the court, you may get the very same result as the individual who had the bail money. And so it appeared to me that it was a life sentence as such for a very minor crime when you lose your credit. Also, sentencing, we wanted to look at that. And then, of course, we need to look at the ever-present issue of drug addiction and and mental health. So those are the 4 areas that we concentrated on, but Your Honor, they're certainly not all of them, and I look forward to hearing the testimony and also the report from the task force. And then I look forward to the 2020 legislative session, working with my colleagues in the House and the Senate to draft legislation to begin to deal with these issues over the long term. And with that, I thank you very much, sir.
Thank you, sir. And we've also asked Representative Greg Sturwald, co-vice chair, to make a few opening comments. House District 40. Representative Sturwald?
Thank you, Your Honor. I appreciate the chance to give a little history and remind us all the work that was done initially on House Bill 1006, the original sentencing reform and criminal code reform bill, and also the actual intent and purpose of that bill. Prior to 1006 being passed and the effective date being July of 2014, the last time a thorough comprehensive review of the criminal code was back in 1976. It passed January 1st, 1976. From that date until when we looked at it over those 4 or 5 years, there were quite a few amendments and bills that were passed amending the criminal code, which in my opinion got it out of disproportionality and also lacked the consistency in sentencing the victims wanted to have. So Governor Daniels established a bipartisan group called the Criminal Code Evaluation Commission to take a look, starting in 2010, at a thorough review of the entire sentencing and criminal code that existed at that point in time. The Criminal Code Evaluation Commission sanctioned a staff committee chaired by U.S. Attorney and U.S. Assistant District Attorney Deborah Daniels, and she formed a team consisting of representatives from the Prosecuting Attorney's Council, the Public Defender Council, the Judicial Center, the Attorney General's Office, and 2 private attorneys who practice criminal law in Indiana. They took a look at every crime in Indiana, every line, and they spent thousands of man-hours doing that just as a subcommittee. And they made recommendations to the Criminal Code Evaluation Commission. The commission itself had dozens of meetings. Here again, even beyond what the subcommittee did, the first thing that I did when that task was handed to me was I called a meeting with the Prosecuting Attorney's Council and the public defenders to begin the process, and that led to the formation of the JRAC, which is the Justice Reinvestment Advisory Commission, because those 2 groups grew into the Department of Corrections, the Probation Association, Community Corrections, the Sheriff's Association, the Indiana Criminal Justice Institute, and once that draft was given to us, we reviewed that prior to any public meetings on the bill itself. So there were probably, and this is my estimation, there were probably 40 to 50,000 man-hours that went into those 4 years of study on the criminal code revision. It was passed in 2013. A great recommendation from my friend Dave Powell said, Representative Sturwell, this is such a huge task. Why don't we make the effective date July 1st of 2014 so we can have an entire year to take a look at this and see if there's anything that we want to redo or take another look at, which turned out to be a very good recommendation, and we did that. So we came back a year later after all those 50 or 60,000 man-hours and reviewed it. We did make some changes, and we introduced the bill that would become known as 1006. Of those groups that I mentioned, I think every group involved supported the bill. The one group that had hesitation, I took no offense, that was the public defenders, but every other group in that JRAC committee supported 1006. Just real briefly, the intent of 1006 was to reduce crime by promoting the use of evidence-based practices for rehabilitation of offenders in a community setting. All these were based upon the Constitution of Indiana. I used this phrase so much back in the day, I got tired of saying it, but I haven't said it for years, so I'll say it now. The kind of fundamental basis was we were trying to separate the people we're mad at from the people we're afraid of and deal with them differently. The other purpose was to keep dangerous offenders in prison by avoiding the use of scarce prison space for nonviolent offenders. Judges were given the maximum discretion to impose sentences based upon the consideration of all the circumstances of the crime. We had to maintain proportionality of penalties across the criminal code with like sentences for those crimes. I have two examples. One was under the old code, for certain very small amounts of cocaine, it had a greater penalty than the most severe sexual assaults. And then the last purpose was to make the length of sentences served by offenders more certain. You may not remember, but we had instances where people were sentenced to 20 years for child molestation, and one person got out in a little over 4 years and showed up where the victim was working out. So we needed consistency and we needed proportionality. So those were the basis of the original House Bill 1006, and I appreciate to this day the support that was given and the unbelievable number of man hours that were given by each and every group and the support that they gave. So thank you for your time.
Thank you, sir. Please remember, those of you that are here, those of you that are tuning in, that if you've not been asked to provide a presentation at either this meeting or two subsequent meetings, or have not signed up on the web or in person to speak, or perhaps you've signed up to speak here this afternoon and perhaps we will not have enough time for you, there is a place on the website to submit your written comments through November 8th at 3 p.m. All comments received by that date will be considered in addition to the information presented at any particular task force meetings. We have two additional task force meetings scheduled. One is October 30th and one is November 6th. Information on the exact locations and times of those meetings will be posted on the task force webpage. The task force could, in its discretion, schedule additional meetings, and we'll keep you posted as to that. The website behind me is readily available for you. The task force is required to submit a final report and recommendations by December 1st, 2019 to the General Assembly and a few other organizations. Again, this meeting is being recorded and broadcast live on the internet. In addition, the proceedings will be archived and placed on the task force website. If you haven't, I would ask you to please turn your cell phones off. We don't want to interrupt any of the presenters. We want everyone to be able to hear the comments. If at some point in time, particularly those in you back, have trouble hearing, give us the universal sign for I can't hear, just wave, or something like this, and we'll endeavor to improve the sound. Our goal is to listen to your remarks. A few of us may have questions for the presenters, but we want to be able to listen carefully to what each speaker has to say. We know all of you will, but we'd ask you to minimize or refrain altogether from any sidebar conversations where you're seated, because that could distract those around you and also the presenters. Again, our challenge is to ensure as best we can as Hoosiers that we have the right people in jail for the right reasons for the right amount of time. We will start with our presentations at this time. In our first presentation will be that of the Association of Indiana Counties. Before we do that, task force members, one item of housekeeping business, and that is you have received a copy of the draft minutes of the last meeting. I believe you had an opportunity to review those at our executive session prior to this meeting, but I invite you to look at those again, and if there are any additions or corrections to those minutes, we should address those now. If not, I would need a motion to approve the minutes as submitted. Is there a second?
Second.
All those in favor of approving the minutes signify by saying aye. Any opposed? Thank you. Motion carries. Again, we have 3 scheduled presentations. Each presentation will be approximately 30 minutes, including questions from task force members, and then we'll have the period of public testimony. I believe we will need to take a short break after the second presentation. We will not commence until everyone has opportunity that is chosen to left gets back in. So at this time, we're going to have the presentation from the Association of Indiana Counties, and would ask Dave Bodorf to come forward. We are ready for your presentation, sir.
Thank you, Justice David, and members of the task force, and honor for me to be your first testifier here this week. I appreciate the court administration working around our annual conference and have this event here in Orange County. Very much appreciate that, and we do look forward to working with the commission not only through this year, but on this issue really for the next several years probably. So again, my name is David Bodorf with the Association of Indiana Counties. I just listed for my own purposes the task force's recommendations so to keep me focused as I was working on my presentation. But we appreciate everything that the state court administration has already done on this endeavor as far as trying to improve public safety, and as others have said, making sure we have the right people in jail or in prison, and trying to help those who are suffering from addiction services or mental illness. And I appreciate so much that the court administration has reached out to us to be a part of the evidence-based decision-making statewide team. I appreciate everything that the court has done with special drug courts and veterans courts. We need to do more of that, and support the development of the risk management programs that have helped judges gather more data on those who are appearing before them. And again, I just want to mention the opioid summit that the Supreme Court, State Court Administration held last year, and the pretrial summit at the end of this week. I think that's fantastic, and so happy to work with such a court that is trying to improve the quality of life for their customers. If I can quote the Chief Justice from her presentation in the General Assembly when she referred to people who appear before the court as their customers. And it's just great to work with such a progressive and forward-thinking administration. This 1006, which Representative Sturwald mentioned, several states have gone through this process, and really it's a fundamental change for local government. And moving forward, we're going to have to become better and try to adhere to some of the objectives and goals of House Bill 1006 and sentencing reform. So the General Assembly, I think, expects counties and jails and local governments to do something different than we've done in the past. And then also, I'm going to talk a little bit about the public expects local government and jails to provide different services. And there really are dramatically different services than what have been perhaps expected from jails in the past. I mentioned other states have gone through this process. Texas went through this process, and this is the perception initially that came out of Texas, and they're making progress on what I would call phase 2 of criminal justice reform. And then California was perhaps one of the earliest or the earliest adoption states for sentencing reform. And so, again, they've gone through this process. They're maybe a couple years ahead of us on their phase 2. And their phase 2, I'm not saying is the answer, but what I'm trying to indicate is that we do need a phase 2 from House Bill 1006, I think, to try to address the jail overcrowding and try to improve services that are offered at the local level. You can see from this quote from the Public Policy Institute of California, their jail population was actually declining, and then they did their sentencing reform, which did increase the jail populations. It definitely helped the state with their prison population, but it caused stress at the local level with the sheriffs in California jails. So their next effort was what they call Proposition 47, which dramatically reduced some of the penalties for lower-level drug and property crimes. And that had a significant effect on jail population. So prior to Prop 47 passing, they had reached a high level of incarceration at the county level. And then after Prop 47, the population immediately began to drop, decreasing more than 10% in the first 4 months of that. And again, I'm not saying that that is what we have to do. I mean, maybe it is time, again, to look at some of the lower level crimes, the nonviolent crimes, and see if incarceration in the jail is the first step, or should that be, the last step. This is an Indiana statistic, what's happened with level 6s at the local jail. Again, I know we've had a lot of conversations through study committees and others about why this is happening, because the intent was not to have the level 6s in prison or in county jails, but to try to provide them services. So again, I think this is just part of this transition that we're experiencing in Indiana, where there's maybe not the level of programs at the county level to handle some of these people who are no longer going to DOC. So we're having this spike right now in level 6s, and again, it's not in every county. A couple weeks ago at the Summer Study Committee of the General Assembly, it was mentioned 2 similar-sized counties had dramatically different level 6s in their jails. I think one county had 11, and another county of similar size had 124. So we have to drill down and figure out why that is happening. And I know that the State Court Administration and the Sheriff's Association and our association are trying to dig down and try to find better data as to why this is happening, why these people are in the level, why they're in the jails. And gathering data has been a little bit of a difficult process, but I think we're making progress. And we're trying to figure out at the county level, from a percentage standpoint of going back to maybe 2008, what was the jails percentage of the county budget back in 2008 and what is it now, and see if we can do a comparison as to some of the things that have transpired. But I suspect that we're spending more and more, I know we are, we're spending more and more on jail services than we ever have in the past. And some of that's related to pretrial issues, and some of it's related to level 6. Now, this is a national statistic here, but again, this is happening across the country. We're having more people in pretrial. And again, we're not sure why they're not bailing out. I know that the state court has worked on Trial Rule 26, trying to do bail reform. I think that may be a benefit. But this is a little bit anecdotal, but what we're hearing from sheriffs and sometimes county commissioners, that families have stopped bailing out because their expectation is that people are getting treatment in the jail, that they're safer in the jail because they won't have access to opioids or drugs or other addictive products. So this is a little bit of a national phenomenon, and we need to gather more data as to why we have this pretrial growth as we do it, but it is very dramatic growth in the pretrials. This came from the Sheriff's Association through DOC. But this is the number of county jails that are above 80% capacity and over 100%. So we've heard a lot of discussion about why all these new jails. Why is everybody, jail expansion? Is it because of level 6? Is it pretrial? Or what is the reason that so many counties are looking to build or expand jails? And some of it is just the age of the jails, that the jails are older. New jail standards talk about line of sight, trying to keep convicted inmates away from pretrial inmates. And so the counties are in a position of trying to build better jails. And again, some of it can't be related to level 6 or pretrial. Some of it's just the age of the jails. So this is a nice statistic that kind of shows that, how old jails are. And because of jail standards, they do have to be updated. Jails have to be updated periodically, and sometimes you can update your existing structure, sometimes you can do an add-on, and sometimes it's just because of maybe population growth in the county, it's just time to build a new jail. This is the other facet I wanted to focus on, is not only does the General Assembly and the state expect more out of county jails and local units of government, but the public does too. So this was a national survey that was really from 2017. And you can see that the average citizen expects what they expect out of the jail. And this really is not what jails have done historically. So again, this is kind of a bit of a game changer, I think, 1006, and the public's attitude about what they expect out of a jail. They're expecting jails to provide rehabilitation treatment. And sometimes they can do that within the jail, but oftentimes that the jail is not the proper place for mental health treatment or addiction services treatment. You can see 73% of people support pretrial services. And again, to me, that means we have to focus on pretrial services and perhaps come up with more money for pretrial services and offer a more robust cafeteria or menu plan for pretrial service so that we can focus on the individual and figure out what kind of treatment services they need. This is just more of this public perception of jails. Again, 62% of Americans believe that rehab or treating the person is the appropriate response for a nonviolent offender, and putting them in jail oftentimes mixes them with violent people. And we'll talk, another presenter will focus on that, how the level 6 perhaps has brought a more violent group of people into the county jail, which is now mixing with people who have previously are nonviolent, and mixing that population is causing some problems for the sheriffs, I think. And again, 75% of Americans believe that only the most serious offenses should be jailed. If people have mental health disorders, we should try to treat that and not have that in jail time. So interesting what the public perception is of jails and what they've been historically, and I think what we're going to have to transition to going forward, either at the jail or at the county level, in providing more services. So some of the immediate options that counties are looking at for jail overcrowding, they're trying to work with their other jails who have empty jail space. The sheriffs will contract with an adjoining jail to try to find space for them. Again, perhaps one of the big problems is nonviolent offenders who violate their terms of their sentence or fail to appear. I know the court administration has done a lot with that, trying to ensure that people show up for the court dates so they're not violating their court date and ending up getting arrested again. I think increasing the public defender assistance program could help with pretrial. Funding additional court staff. I mean, it takes time for the court to evaluate these people, figure out what services they need, and then for the court to make a recommendation. And then again, just more robust treatments at the local level. And again, a lot of counties never had these treatment programs in the past. The inmate would go to DOC, who would have programs for them, but now that they're staying locally, we have to look at the counties to focus on creating more and more programs and have more and more space for people who have addiction services or mental health disorders. You know that this has been a focal point the last couple of years. Counties have asked for a reimbursement, a higher reimbursement for level 6 offenders. It's been $35, I think, for over 20 years. The General Assembly finally increased that to $37.50 this year, expected to go to $40 next year. But one thing to remember about that, the General Assembly put a hard cap on that dollar amount. So if the level 6 population grows at the county level, we're not going to see $37.50 per inmate. We're going to see whatever money is available will become the reimbursement rate. One thing I think that we should consider is we only get the $35 if they're in jail. And there are lots of grant programs, community corrections programs, there's programs through the state court administration, there's programs through the Attorney General's office for addiction services and pretrial. But if we're gonna have these local 6 people at the county level and to only give the reimbursement if they're in jail, seems like we should look at a reimbursement rate for every level 6 that's under the county jurisdiction, and maybe $35 isn't the appropriate amount if they're not in jail. But again, some counties have a much larger population of level 6s than others, and so a reimbursement rate tied to the level 6 whether or not they're in jail, on probation, or community corrections. Reimbursing the counties for everybody under their watch may be a better option. This is just kind of reiterating that point that it seems kind of odd. I don't want to say the county gets rewarded, but the county only gets money if they're in the county jail. So, and again, I think Representative Sturwall, right? I know he and others spent hours, days, weeks, months evaluating level 5, level 6, reclassifying all the crimes in the state. But it may be time again to look at those again and see if there are some items that are level 6 that could become infractions, or maybe some of the level 6 actually need to become level 5s, and that would help, from our perspective, help shrink that level 6 population, because it continues to grow every year. It seems like that the number of people who are convicted of level 6 versus the rest of the different levels of crime. A couple options, I think, that we would ask the General Assembly to take a look at. 2 years ago, it used to be every county, when they needed a new jail, they would come to the General Assembly and say, can we have a special income tax rate to build a jail? And usually the General Assembly granted that. And then, so 2 years ago, the General Assembly said, we're just going to give everybody that special rate to build a jail, 0.2%. And when it initially passed, it was pretty wide open of what you could spend that 0.2 on. It was for corrections facilities and rehab facilities. And then last year, the General Assembly tightened that up and said, we can only spend 20% of that jail income tax on operations. The rest of it had to be spent on capital. So that kind of tied our hands and restricted us. But if we're going to call that, we call it a jail income tax, but maybe we should change the name to a jail reduction income tax and free up that money so that counties can spend that on programs that actually decrease jail population, and not just say you only get to adopt it if you have to build a new jail or have to expand your jail, but you give that flexibility to the locals to help create programs to divert people from jail, and not just say you have to build it on the jail. The other thing we would look at is the public safety income tax. Again, it was originally designed, I think, to be, to help the county with their increasing cost for jails and new courts, probation, community corrections. But the way that money's divided up, it's really based on levies. So each civil unit, this gets in the weeds a little bit on how income taxes are distributed, but each civil unit gets a piece of that public safety tax, sort of whether or not they need it or not. Just if they had a levy in 1970s, they get a piece of that. And if they had a high levy in the 1970s, they get a pretty substantial piece of it. So it's not tied to their need for public safety. I think everybody would agree it's the county who has the biggest bulk of public safety, with the courts and the jail, community corrections, probation, public defenders. So looking at how that public safety income tax is divided up, and I think gearing it more towards where is the need for public safety versus just everybody gets a piece of this public safety income tax, I think could be really advantageous to the counties. A couple other options: when a new court is created, if the county could ask for a levy increase, that would help take the pressure off of any resistance at the local level. I think having misdemeanors become eligible for recovery works would be something we would advocate for. And then we're all paying attention to the opioid lawsuit, hoping that if there's a settlement on that, or the case goes to trial and there's money coming back to the counties or the state, that money be used for directly to the counties as much as possible, and that money's used to supplement whatever the state's doing now or whatever the county's doing now for recovery programs, and it's not used to supplant that. So if there's money coming back, we want to see that money go into treatment programs, and as much of it directly to the county, I think would be a benefit. And the last thing I'll mention, this is really a federal regulation, but I just want to put it on your radar. We've talked about this. When an inmate gets picked up, if they're on HIP 2.0, if they have veterans benefits, when they lose their freedom of movement, the county is supposed to notify the feds that this person's been arrested and their benefits are suspended. So if that person then, though, goes out of the county for treatment, that can be reinstated if they have presumptive eligibility, or if it's a veteran and the sheriff takes the time to or the sheriff takes them to the veteran services outside the jail, the person can get reimbursement for that. But while they're in jail pre-trial, and they need the health service that we have to administer in the county, inside the county jail, the county's picking up the full boat of that health care. And to me, it seems like we should evaluate why somebody would lose their benefits if they haven't been convicted of a crime yet. The state has made some progress on this. So for people who are in community corrections, they're eligible to keep their benefits. Here's a list of the programs that have that. And then below, on the bottom of that is the mixed status programs, and those are done on an individual by individual basis. But we're actually working with the National Sheriff's Association and the National Association of Counties on that program to try to see if we can keep people on their benefits plans when they enter the jail and not have them suspended automatically. And thanks, and I continue to work with you all. And I have about 10 minutes left, and I want to turn the remainder of my time over to John McKnight with Bliss McKnight. And they do a lot of work with counties and county sheriffs about how to make your jail more responsive and safer. And so if it's okay with you, before I maybe take questions, I let John go, and then I'll be here to answer any questions, if that's appropriate.
Certainly.
He'll be part of our 30 minutes.
Thank you. We may have a couple questions
Okay.
at the end of your collective presentation.
Justice David, members of the task force, thank you for not only having this hearing, but also for the way in which the executive branch, the legislative branch, and the judicial branch have come together to work on this problem. A lot of states and certainly the federal government could certainly learn from your model of problem solving. The problem you have here, though, with the overcrowding position in jails is one that's very comprehensive, and I'd like my comments to be looked at not as criticisms of any particular factor, but simply giving you an idea of some of the consequences and unintended consequences, as well as unfinished work that we would hope would follow in phase 2 or 3 or to deal with this problem. My position, my perspective is based on the fact that for the last 40 years, we have been ensuring, defending, providing risk management for Indiana jails or Indiana counties and their jail operations, as well as because we manage a not-for-profit insurance company owned by its participating local governments, we have every incentive to also pursue case law through both the Seventh Circuit Court of Appeals and also the United States Supreme Court when we have the opportunity to make good law on behalf of our client counties. To that end, we have been not only the Seventh Circuit quite a few times, but we've been to the United States Supreme Court 25 times, prevailing 21 of those times, in pursuit of good law to make possible the difficult jobs that the county officials have. And in recent years, the subject matter of those appellate efforts have been in law enforcement and jails, because that's the hot topic. Now, we've all talked about the jails, and we know that many of them are old, they're in disrepair, or they lack modern design. And when it comes to the liability of counties, even if they're regularly updated or expanded, there's a difficulty in causing an old building to meet modern standards. And when they're in an overcrowded position, it's just like driving your car really, really hard. It wears out faster. So overcrowding increases the wear and tear on already old infrastructure. And as a result, systems are failing with increasing frequency. The jails, the Supreme Court has determined that jails also are subject to the Americans with Disabilities Act, and the most recent modification of the ADA has been to redefine what a disability is to encompass just about everybody. So you have a plethora of cases where prisoners are asking jails to accommodate all manner of things, and jails have no choice but to try to accommodate those things. And as we all know, there's been a major increase in the overall population of jails. This is in the graph of what's happened in Indiana, and in recent years that has been particularly an acute problem where the number of people going into county jails has outstripped the capacity of jails, to the point that using the most recent report from the state, 77% of the jails now are overcrowded, which is above 80% occupancy, or overcapacity, which is 100%. Generally speaking, liability issues begin to greatly increase when occupancy exceeds 80%. So the demands on jail staff are also changing, not only with a growing number of prisoners, but there is a major shift in the demographic changes and the social expectations that our jails are supposed to be delivering now to prisoners. As an example, on one end you have an increase in prisoners with a level 6, influx of level 6 felons, and on the other hand, the opioid crisis has brought brand new classification of people into the system, many of whom are almost accidental criminals because they got caught up in not your traditional way of getting caught up in drug use. So you have the culture changing, shifting towards the people who were in jail for the longest and also have the highest skills as prisoners, which are level 6, and this new crowd of people who's coming in who are like sheep before the slaughter when they go into a jail situation where they're afraid, they don't have prisoner skills, and many of them are very badly sick because they're addicted to opioids. So this creates new workload demands on staff, and when you go into an overcrowding situation, the federal courts have begun to notice that an overcrowding situation increases the workload and the difficulty of managing a jail. So you not only have an increase in the ratio of corrections officers to prisoners is going in the wrong direction, but the workload of the corrections officers for the prisoners is also going up. And it's reported that 82% of the jails are understaffed at this particular point in time, which is a very difficult situation. When you have an understaffed jail, in essence, you basically try to keep the lid on it, but your ability to deliver services and also to take on the additional challenges of what the modern day jail has to offer is consuming staff time and resources. There is in the future an observation we've made, even with the money coming in through the income tax, which is terrific, and we hope that all counties would choose to adopt this. We have an improved economy, generally rising wages, lower unemployment, and a wider range of employment opportunities. And this is particularly important in that the employment opportunities for the people who are currently corrections officers and who in the future might consider being corrections officers have more opportunities. And if any of you have seen what the challenges of being a corrections officer, it's not a job for everybody. The increased set of opportunities and alternatives for people who might be corrections officers or people who are currently corrections officers who might be looking for a different line of work are expanding. It's going to make it more difficult, and supply and demand is very likely to make the cost of an individual corrections officer currently and future that you want to recruit go up. So there's two graphs that show from the Bureau of Economic Standards, Department of Commerce. The employment rate in Indiana is, the unemployment rate has gone down, and the non-farm employment jobs have gone up. Now, the introduction of level 6 felons into county jails has used up a significant amount of county jail capacity. But it's more than that, because with the level 6 felons, including those people who are actually, their crimes may be more than level 6, but they've been plea bargained to level 6, are a difficult group of people and have characteristics different than what has traditionally been in county jails. And that produces new challenges to jail management. Many of them are very savvy. They know how to work the system, and they are working the system. We have never seen such a perfect storm of characteristics coming together with jails with respect to generating liability, or at least charges of liability against the sheriffs and the institution of the jails. This is the graph that you saw before. It just shows that there's been a very substantial and rapid rise in occupancy of jail beds by level 6 felons. But there's also the other side of it. There's a change in jail demographics, not only mixing in the more permanent residents of jails. A lot of the other people in jails are transient, which is the level 6 people are permanent or there for the longer duration. Lots of transients make up the rest of it. The female population is growing. Jails, when they were built, oftentimes were built under the assumption traditional ratios of male to female. Now we have a lot more female, and that's a real problem because jails don't accommodate themselves to remodeling too easily for the very reason that they're hard to get out of. The number of prisoners with serious medical issues is increasing as the opioid crisis brings in people who are very, very sick, and if they're not taken care of, then their sickness could be fatal, or it could certainly make it much more difficult and expensive to house them as prisoners. Gender issues are emerging. I've been asked to stop. You want me to continue, or do you want me to?
Can you, in the interest of time, do you have a couple of points you want to make in concluding your presentation? Give the task force members an opportunity to ask you, Mr. Barr, if any questions.
I could do that, or I could, after everybody else is finished, I could come up and continue. Would you prefer that?
Maybe that would be a good course of action.
Okay.
Justice Goff, Representative Sturwall, Representative Gasco, any task force members, do you have questions for either presenter? Then if possible, if you are going to be here, that would be wonderful.
I'd be happy to do that.
Thank you both very much. We'll now hear a presentation from the Indiana Sheriff's Association. And in case any of you are wondering why some of us are looking over our shoulders and some of us are looking down, we also have a monitor in front below your eyesight. So those of us without corrective surgery may be looking behind, and some of us who have it still may be looking behind. We also have a monitor up front, and I don't know about you, but I was born in northern county, raised in southern county, and I live in a central Indiana county for the last 31 years, and I've realized that our county sheriff is here, and you may not be worried about it. I'm worried whether he's here in his official capacity as a member of the Indiana Sheriff's Association or whether he's here to arrest me. So I guess we'll find that out at the end of the meeting. So we're ready for our next presenter. Good afternoon, sir. If you please introduce yourself for those of us or those that are tuning in via the web.
Good afternoon, and thanks for allowing the Indiana Sheriff's Association to present. On behalf of the Indiana Sheriffs, and first of all, I would like to introduce myself, Steve Luce, retired sheriff, retired in 2009. Was a sheriff in Knox County. Prior to that, when I inherited the job back in 2002, I had 70% of my inmates had a methamphetamine charge, so we had a serious problem. The only thing I can tell you is when I retired, I probably got out at the right time, because society has changed quite a bit. The offenders are more chronic, and I can only credit the sheriffs for keeping the lid on a pressure cooker that is going on right now. Before I get started into the presentation, I just wanted to real quickly go over the powers and duties of the sheriff. And it's not going to take very long because there's only 8. And keep this in mind, what they're tasked to do through our state constitutional. And as we go through this process, what they're doing today to show you how their job has changed, not only for the people invested, the citizens, but also to make sure these offenders get through a successful incarceration period, handing them off to the Department of Corrections, or if they're going back out to the community. The sheriff must arrest and process all persons who committed a new offense within his view. Sheriff must suppress all breaches of peace. Sheriff must pursue to the jail all felons. Sheriff must execute all process directed to him by legal authority. The sheriff must serve all process directed to him by the courts or county executive. The sheriff must preserve order in all courts. The sheriff must take care of the county jail and prisoners. And the sheriff must process all offenders. What I would just tell you would be the intake process, fingerprint, and photographs. Those are the 8 duties of the sheriffs in our Constitution. The first thing I'm going to talk about is the use of jail data. One of the things that we struggle with, not only in Indiana, but nationally, is collecting real-time jail data. And I'll give you an example. 2 years ago, the Indiana Sheriff's Association had scheduled several roundtables in the spring. I think it was 7 or 8. And what I found out was about halfway through these meetings, half the sheriffs were dealing with methamphetamine again. And we were also focused on the opioid. So when I talk about jail data, you know, having jail data real time will allow us to, I believe, identify those trends. Because when I get my jail data from the sheriffs, it could be 30 or 60 days old. That's enough for a new trend. So in Indiana, there currently exists no mechanism to gather jail data to determine incarceration trends across the state. With the majority of Indiana jails facing crowded conditions, the question is, why are so many of the jails in Indiana experiencing crowded conditions? The current method of soliciting jail data is using surveys. The method is slow and unreliable. The state of Indiana should produce a more efficient method of capturing this data in real time. So what we're doing, myself, as a director of the Indiana Sheriff's Association, I've assigned 2 sheriffs to work along with Commissioner Carter, the governor's office, and some other stakeholders, along with CJI, to put out an RFP, hopefully, that will allow us to bring all JMS systems together. We have about 15 to 20 in Indiana, to where we can link and pool the right data on a daily, real-time view. That dashboard would be available to everybody from local government to state government, all the criminal justice stakeholders. Me, if I had to rethink 1006 when we instituted it, I probably would have went back and said, hey, we got to create this infrastructure first. But you know what? We moved forward. We didn't think of that. But now I really believe 6 years down the road, data is so important to drive legislation. It could be that we're not appropriating new money. Maybe we identify a trend in a jail or a community or a region, and we can shift those dollars over to here because that's where the problem is. So I think we're going to be able to work smarter and not harder because we have better jail data. Pretrial. Pretrial spans a point of arrest through disposition of a case and includes diversion, jail, pretrial release, and court processing. Decision makers include police, prosecutors, judges, magistrates, and pretrial services professionals, all of whom aim to strike a balance. I'm going to go back to 2002 when I was elected. Our county, we were in a private agreement on a federal lawsuit, And what our county did is we really brought all these stakeholders together, and we were able to find out, and we were able to manage, because I had a soft cap of a 48-bed jail. Every Friday at noon, I had to have my population down to 84. So we came together, we created the balance that I'm talking about, from the judges all the way through the sheriff's office, through probation, court services, and everybody. And for 2 years, until we got the jail built, we were able to manage our population. So I think communication is an important part in making sure your jail does not get full. And we have to strike that balance between due process for the defendant. Public safety is very important, because there's a lot of sheriffs in here who take their job, as I gave you the duties of the sheriff, to pursue and jail all felons. We still have to make sure the right people are in jail and the courts are efficient. Jail incarceration, some reasons people are waiting for trial for a criminal offense. We find that is a big reason why the jails are stacked. People serving time for a criminal offense, people who fail to appear for a court hearing, people for violating terms of probation. Case management, and I've talked to several sheriffs, once they're released, that case management is very important to the offenders. And like I said earlier, we are dealing with a different offender than we had 10 years ago. If I had a pill for why people can't do what they're supposed to between that time when they're released, you know, we would probably not be seeing the overcrowded jails. But something, by the time they're released, till they can get to the services or appointments, they're failing. And I'll discuss that a little bit later on a recent trip I took to Philadelphia. People are violating terms of parole. People are convicted and sentenced and waiting to transport to prison. People for short terms holds for federal government and other counties. Police in the decision to arrest. According to Timothy R. Snacky, law enforcement in the United States, approximately 12 million people are arrested a year. He wrote a nice review that's only 66 pages long for the American Bar Association, and it really outlines the history of bail or no bail. It really talks a lot about pretrial release and the history of pretrial release in America. And one of the things I really picked up on, and it really starts with how the judges have to really create a balance through the criminal justice system. Between 2004 and 2010, total stops increased from 92% and arrests increased to 155%. An arrest is made in the country every 3 seconds, approximately 30,000 arrests per day. I think those stats are very important just to tell you how busy we are today with public safety and enforcing who's coming into our jail and how busy the law enforcement officers are. The courthouse. Once arrested, courts need to decide whether to hold individuals pending trial, release them with conditions, or release them on their own recognizance. Many arrested individuals spend at least some of the time in jail before trial. According to the Bureau of Justice Statistics in 2018, update on prison recidivism, inmates who are incarcerated once, even for a short time, are more likely to be incarcerated again. America leads the world in pretrial detention at 3 times the world average. The federal government estimates that approximately 38% of presumptive innocent felony defendants are detained for the duration of their cases, and of those, 90% remain in jail because they can't afford to post bail. And I think that's why our Criminal Rule 26 is very important, that we're going to start here for everybody in January. Cost of pretrial detention. According to a report by the Pretrial Justice Institute released in 2017, U.S. taxpayers spend approximately $38 million per day to jail people who are awaiting trial. 63% of total jail population, or more than 750,000 individuals on any given day. That tells you how crowded our jails and prisons are. The report noted that the amounts around $14 billion annually, which could cover the cost of 300,000 firefighters or 250,000 elementary school teachers, or provide free or low-cost lunches for 31 million children. Many people in jail have behavioral health needs that would be better met outside the justice system. 1 in 5 jail inmates have a serious mental illness. Only 11% of people with substance use disorders in the justice system receives any type of treatment. People with low income, physical health needs, substance abuse disorders, homelessness, low income levels, and again, an important reason why Criminal Rule 26 is important. The benefits of managing pretrial risk. The use of money, bail in most U.S. jurisdictions allow wealthier arrested people to buy their freedom, regardless of how dangerous they might be, while simultaneously jailing poor and working class individuals who could be successful in the community before trial simply because they don't have the resources to pay their way out. A common sense alternative is to give the courts better information about the people arrested and a wider menu to choose from when the court sets and releases the conditions. Recently, myself and Bill Wilson of the Indiana Sheriff's Association, we attended a 2-day workshop last week in Philadelphia Bureau of Prisons, which is actually jails, but they call their system prisons. The facility we went to was a female facility, Riverside Correctional Facility, and we also visited a men's facility. From the time they hit the door, and one of the things I've talked about for a while is the one thing I can always tell you before an offender comes through the system, they're always going to come to the jail first. That's what they did in Philadelphia. When they hit the door, they have a process of about 9 steps. Before you can get to door number 9, they are interviewing, asking questions, and if there's anything that red flags in their software, it automatically makes a note so they get the right appointments. So having those steps up front, and we've done a really good job during 1006 with Recovery Works, releasing the offenders, trying to get them on their way. But I guess I could never understand, and it seems to me that when they first come through the door, why we're not putting a better outreach in front to get more information from them to all the stakeholders in the system. The trip in Philadelphia was very impressive. Even upon release, some of the individuals, depending on the program they go through and who the partnerships are with, they take them right to those facilities to make sure they get signed up. So I would recommend maybe Department of Corrections, if you can spare a couple people to go out there and go through the program that they've established. It's a national model. Their medical provider also assists with that. We were able to bring back a lot of information that I think would be very helpful in this critical time when they're entering the jail. It has been estimated that implementing validated evidence-based risk assessment to guide pretrial release decisions could yield $78 billion in savings and benefit nationally, the report concluded. And I talked about the jail data thing. There's just a slide here about Santa Clara County, California, which does have a dashboard that's available for everybody in the criminal justice system in that county. When we send the link out from the presentation, it's pretty basic. It just goes in there. It gives you a real nice snapshot of who's in jail, what the recidivism rate is, male, female. So this is data that we need to drive the right solutions, because I think we're all struggling with who is in our jail. Recently, as I spoke earlier, the Sheriff's Association, we did do a jail survey. It took me about 30 days to get it back. The slide says 89 county jails responded. That's how many responded by the time I had to get this report ready for Mary Kay. We did have all sheriff's office respond. I don't think 2 counties is going to make a big difference on the data that we have, but in the report, it said 11 jails report overcrowding at 120% or more of the capacity. 8 jails reported crowding between 110 and 120% of capacity. 14 jails reported crowding between 100 and 109% of capacity. As you can see, I'm just going through and telling you that the jails, and we all know that, are very much overcrowded. Jails that are alleged to have violated constitutional rights are because of overcrowding. And because of the overcrowding, it's not the overcrowding that gets you sued, it's the conditions that are created in that jail. When you have a lot of people being housed, you most certainly have a lot of liability, not only to the sheriff, but to the county, but to the citizens also. Typically, what you're seeing in the county jail because of overcrowding, breakdown of inmate health and safety concerns, lack of inmate recreation, lack of inmate welfare checks, increase in inmate violence, lack of jail staff that we just heard about. Being able to manage a jail, one of the duties the sheriff has is to make sure that that jail is not only safe for the inmates, but safe for the workers that are there. So, quick summary, jail overcrowding is managed by decreasing the rate of inmates entering the jail, increasing the rate at which inmates leave the jail, or a combination of both. Building bigger jails should not be the first option. That is the end of the presentation. I think I made it within my time, Mary.
Thank you. Sheriff, Senator Gaskell, Representative Sturwald, Justice Goff, members of the task force, any questions for? Yes, sir.
Thank you, Justice David, for recognizing me. One question for you, Steve. You mentioned about your visit to the Philadelphia. Do you know if any of our sheriffs are completing like an upon arrival assessment? And what I mean by that is, does anybody from the jail staff sit down with the inmate and ask, how did you get here? So that way we can start to identify some trends and maybe get some data on that. Do you know if that's happening?
Yeah, I believe, I can't speak for all 92 sheriffs, but I know that some sheriffs do have those community resources to where when they're coming in, they've taken a good time to come up with probably their medical contractor too, because some of these things are medical. They're going to have the input. But I am aware of several sheriffs they're really kind of out in front, but then the sheriffs who are having a hard time is simply because they're understaffed to make sure that first contact and those questions are always asked, because you could easily be interviewing an inmate, an offender, and all of a sudden something happens and you've got to leave. So that is one of the things, the big takebacks I had from Philadelphia was the amount of questions. And once an inmate there is actually being processed, they do it within 4 hours. They have a form where they ask them 132 questions.
Okay.
And as they're going through this whole process, it is being flagged in their computer to make sure if someone gives them the answer, it flags in the computer where they might go and what services they might get. So.
Yeah. Thank you for that. I mean, in preparation of this task force, I visited the different sheriffs, the counties that I represent. In fact, Sheriff Nielsen's in the audience today, and I remember distinctly one of the things that he said to me was one prisoner just no one ever in his life ever believed in him. Yeah. And so I'm wondering if that could be something that the rest of our sheriffs could fill out and then be uploaded to a system so we can start looking at data as to how people are landing in our jails to begin with.
Yeah, and one of the things we were able to be part of a panel out there, and as the offenders were talking, this was at the female facility, and sometimes it's just not listening to why they've gotten rearrested. Someone may not just want to give them the time to hear their story. For example, there was one female there that she simply stopped doing what she was doing because her boyfriend, who was father of 4 kids, died. So she immediately said, I'm not going to the appointment. This is what I'm dealing with. And she went back on the drugs. So I think it's getting the people who are qualified to make those decisions, because the jail staff, they're very tasked with what they have to do. And I think if we can find a system of best practices or these uniform questions we need to ask that is going to red flag the people during that interview or intake process, in those communities such as Sheriff Nielsen can work with those providers to get right on this person and what their needs are going to be, because everybody's going to be different. It's potentially.
And Senator Ford, Sheriff Luce gave you a very good answer to a very good question. That's also a question that Mary Kay Hudson may be able to provide you some additional information as to partnerships and collaboration being undertaken and already developed with our pretrial pilot counties and what's on the horizon there. Yes, sir. Do you have a question? Anyone else have a question? Yes. Representative Sturwall?
Thanks, Steve, as always. I just want to clarify, on the last page of your PowerPoint or the summary, I think you said building a bigger jail should not be the first option. Okay. In mine, I don't know if it's the rest of the committees, but it says last option, so.
Well, we had a couple updates that we did not get in there, so this is the presentation that I'll send out.
I knew you meant first. I just wanted to
Yeah.
make sure everybody understood that. Thanks.
Yeah.
Any other questions? Thank you very much.
Thank you.
We will take a 10-minute recess. It's necessary for us for a couple of housekeeping matters. I'm to remind those of you that if you choose to step outside the room, you'll have to go back through the security. We'll adjourn for 10 minutes. If you can begin to take your seats, we'll try to reconvene just as soon as we can assemble the task force members. Okay, last call, if everybody could take their seat.
It always seems like those happen, and it's that tickle, and you just can't get rid of it. I understand.
Well, thank you very much for your cooperation. We have accounted for everybody, and we will reconvene. All those persons of the task force member who were present when we recessed are again present. And I don't know if there's a country music song, how long is 10 minutes, but I accept full responsibility for giving you inspiration to write one if there's not a country music song. For your information, all 92 counties will be represented at an upcoming pretrial summit on October 4th this week at the Convention Center. What that means is every county in Indiana will have a judicial officer, law enforcement officer, public defender, prosecutor, and other stakeholders meet to talk about Criminal Rule 26, about pretrial best practices. The agenda is nothing short of amazing. Representative Sturwall and the Chief Justice will provide keynote comments. The breakout sessions, the plenary sessions are superb. So every county will be represented. If you want or like additional information about the possibility of do we have additional slots, we have over 700 people attending that already. And you can see Mary Kay Hudson, our next presenter, at the conclusion of this meeting, or you can go on our website and gain additional information. But that underscores how important these issues are to all Hoosiers. Our next presenter is from the Indiana Office of Court Services. I'd ask her to step forward, identify herself, and you may proceed, ma'am.
Thank you, Justice David and members of the task force. My name is Mary Kay Hudson. I'm the Executive Director for the Indiana Office of Court Services, which is an agency of the Office of Judicial Administration. I appreciate the opportunity to address the task force today. I'd like to talk a little bit about what court data is available to assist the task force in making its determinations pursuant to its statutory charge. We have a fair amount of data that we've collected in recent years. Some of it is very much relevant to the work of the task force. Others is more of a statement about the trends that we're seeing in criminal case filings and the types of cases that we're seeing. I'll start by saying that the information that I'm presenting today is really just a snapshot of what we may have available. While it's not directly on point with jail population, it does inform a little bit about what we're doing relative to when people are in jail, how long they're in jail, and why they're in jail. So the first thing I would like to do is just provide an overview of some historical information on case filing data. These are the trends that we're seeing in criminal case filings beginning in 2008 through 2017. This is our latest published report on criminal case filings that's available online in our Judicial Services report. Although we have not published it yet, the 2018 number for criminal case filings is 291,207 cases, which is just above the 2017 numbers. And we expect to have that report published shortly. You'll see that in the past 10 years, 2014 was the all-time low for criminal case filings, but we have been trending back upward for the last 5 years. This slide illustrates more specifically the felony case filings since 2008. We are seeing, again, a trend it was lowest in 2015. We're trending back up in 2017 to just over 77,000. And then our 2018 numbers are 78,244. And again, these are all felony filings. Then when we look at misdemeanor filings, we see some similar trends, but while we are going up ever so slightly on the felony side of things, when we look at our 2018 numbers for misdemeanor filings, we're going down just a bit. We reported 144,833 misdemeanor filings in 2018. This next slide is an overview of case filings in 2018. These are criminal case filings just for 2018 by class of offense, so that you see that overwhelmingly the largest number of cases that are filed are misdemeanor charges, followed by miscellaneous criminal cases, and then when we get into the felony levels, we're looking at a pretty significant percentage of those felony filings are level 6 felons. The smallest percentage of the filings are as you get higher when you're looking at Class A and murder filings. So when we look a little more closely at case dispositions, there's a variety of ways in which cases may be disposed of in the trial courts. You do have in your materials a description of each of the classifications of case dispositions in your materials that will give you a little bit more detail about how these cases, what it means when these cases are disposed in these certain ways. But one of the most common ways in which a case is disposed is by plea agreement. So we see almost 40% of our criminal cases that were disposed of last year in 2018 were done so via a plea agreement. So if we look a little bit more closely at our case dispositions and we look more specifically at sentencing information and abstract data, I want to show you some slides on our sentencing abstracts. Our abstracts of judgments are completed for all felony sentences in Indiana, and they are required to be completed for all felony convictions under Criminal Rule 15.2. So the date range for this presentation is June 1st of 2018 through July 31st of this year. So the limitations of the data that I'm going to show you is that the pretrial credit and sentencing information for other cases, such as misdemeanor cases and contempts, are not available via the abstract process because misdemeanors are not captured in our abstract data. So we do have some limitations on what we can say in the amount of time that's being served pre-trial for misdemeanors. So there's a lot to know about this particular slide. This captures each month from the reporting period of June through 2018 through July of 2019. The most important thing to think about is the overall lines in terms of how many abstracts are being filed on any given month. You see we have variations between months. The lowest for that period of time being in December of 2018, the highest in that period of time being April of 2019. And then if you look to the side, you can see the ways in which the abstracts, the sentencing, the type of sentence for each of the abstracts. And so if you look at not only the height of the bar by the number of abstracts that were filed in that month, you can see by the color or the shading of that particular bar what the most common sentencing dispositions were for those particular cases. So to the right there is a key by color of the different types of dispositions, and you'll see to the right where it says jail only, that is the most frequent sentencing disposition for this set of abstracts. But what I will say about that is this is total placements or total level 6 abstracts for this period of time, which not only includes original sentencing orders and abstracts, but also revocations. And so when we see adding those two types of dispositions together, we have a tendency to see more jail-only dispositions or abstracts because those are violations of supervision, and in many cases, the response to those violations, particularly if there's been multiple violations on any given case, is ultimately a revocation to jail. These are just merely the numbers that support the graph that you just showed, if it's easier for you to see that. And this graph, while it's oriented differently, is laid out the same way as the previous graph in the sense of it lists by type of disposition. the most frequent disposition for the abstracts filed during that period of time. The difference with this slide is it's the same time frame of June 2018 through July 2019, but this contains only original abstracts. It does not include any revocation data. So if we look differently, if we look at this slide in the same way that we looked at the previous slide that includes the revocation data, we'll see that this slide shows that jail plus probation is the most common form of disposition for these original abstracts, followed by probation only and jail only. And this is the numbers that are behind that slide. Another piece of data that the courts capture that could be helpful to the task force is credit time and how that applies and how we are sentencing individuals relative to the amount of time that they earn in pretrial credit and what that means for sentences either executed at the jail level, the local level in the jails, or at the Department of Correction. So just to provide you an overview of credit time can be very complicated. It can be very difficult to work through. It can be there's a lot of information that goes into making credit time calculations, particularly for individuals who have multiple cases and multiple holds. But essentially, overview of credit time is governed by 3556, which provides the statutory framework for how credit time is awarded and calculated. So essentially, you start with a total sentence length, and then you subtract the accrued time that the offender has earned, which is the actual days that they have served pretrial. Then you would subtract any good time credit for the days that they have served, whether that's in DOC, jail, pretrial home detention, which is based upon the credit class of the offense for which they're being held. And so then the balance of their sentence is the remainder of their executed sentence plus any suspended time that they may have exposure to in the event that they are revoked from supervision. When we look at post-sentence credit, meaning what individuals are given credit time for that would take time off of their sentence after that, there could be educational credit from the DOC or from jail programming, or you could subtract any home detention accrued time and good time credit from that. And then the balance is a maximum time remaining on their sentence. So it's important to remember that calculation of pretrial credit is intensely fact sensitive. There is a lot of time and effort that goes into calculating credit time at both the local level at the time of sentencing and also at the Department of Correction when they're making determinations on earliest possible release dates. And because of that, trial court technology has developed the credit time calculator that is available to assist in calculating the amount of time that individuals are entitled to. So when we look at credit time as it relates to abstract data, and it's helpful to know what type of sentences individuals are receiving relative to the amount of credit time that they may have that they've been serving pretrial. So these slides are a little technical, but I think they can illustrate for you the differences that we see in the abstract data when individuals are sentenced for, in this case, level 5 through level 1 felonies, and what role their credit time that they have earned pretrial may play in sentencing, or at least to describe what these individuals look like in sentencing relative to their pretrial credit. So from the period of time of January 1st of 2019 through July 31st of this year, there were 7,976 level 5 through level 1 abstracts filed. 6,790 of those individuals spent time incarcerated pretrial. 1,726 of those individuals who spent time pretrial were given no executed sentence, but they did have pretrial credit, meaning at the time of disposition they were not sentenced to any additional time at the local level or at the state level. And 1,773 individuals had more pretrial credit than actually they had sentence time. So they spent more time awaiting trial than the court awarded them in sentencing at the time of disposition. It's important to know that we don't know why. Again, it's very fact specific, it's case sensitive. Every case is different, but it does give us a sense for the fact that there are individuals who are spending time pretrial, but we would need to look further into this via hopefully at some point jail data to really see the reasons why people are being held. I think it's important to recognize that it's complicated. We can't really draw conclusions from this or possibly even make recommendations based upon this information solely. but it is something for us to take a look at once we have access to the jail data. My suggestion would be is that if we wanted to look into this further, we could look at it more at the case level or at the county level to have a firm understanding of what's happening. If we break it down further and look more specifically at level 6 abstracts, from January 1st of 2019 to July 31st of 2019, there were 28,777 total level 6 abstracts. But for the purposes of this slide, we're only looking at those that were disposed of without a sentence to the Department of Correction. So of the 26,346 level 6s that were disposed during this period of time, 16,887 had a jail sentence. 5,973 of those had no jail sentence but had pretrial credit. And we see that 222,827 days spent in jail pretrial by defendants who were not sentenced to another day in jail. So again, we cannot make any conclusions or draw any conclusions based on the information. We would really need to look at those numbers more carefully to know what's happening. There could be lots of different reasons why people are earning that type of jail credit. So we want to be mindful of that. And then in that same set of individuals, there's 7,688 individuals who had more pretrial credit than they were ultimately sentenced to. I think one of the things to note is that while the abstract data does have good information for the purpose of calculating credit time for sentencing, and we can use some of that information to help guide us in where we need to look for more information, the abstract data was not intended to capture actual jail time. It was not intended for this purpose. So I think we would want to identify ways in which, in partnership with the Sheriff's Association, we can get better jail data to look at the actual and specific reasons why people are being held on individual cases. So there are a few ways in which the Office of Judicial Administration and Trial Court Technology are working to improve data collection through some of the technology features. The first is abstract data. This legislative session, there were some changes in the way or in the circumstances under which a court could return a level 6 offender back to the Department of Correction. In the cases of violent offenders, and if individuals had 2 prior unrelated felonies, if they had more than 365 days, they could be returned to the Department of Correction. So we have modified the abstract of judgment order or the abstract of judgment application so that that can be captured, so that we can collect data on how the frequency with which individuals are being sent back under those terms. We also have a couple of new Odyssey features that I think will assist us in tracking some of our jail data and the reasons why people are being returned to jail. The first is, within the last several weeks, Trial Court Technology has added a feature to Odyssey so that failure to appear can be a specific warrant type that the court notes when a warrant is issued. Right now, there are several different types of warrants that may be issued, and we were having trouble specifically with the pretrial project being able to capture when warrants were being issued for failure to appear in court, and specifically for failure to appear in court at the pretrial stage. So there is now a warrant type in Odyssey where you can flag it so that we will know that was an FTA. And based upon the status of the case at the time that the warrant was issued, we will be able to know that that was a pretrial failure to appear. So that will be helpful for us as we look at our pretrial outcomes. And then we have also, within the last year and a half, implemented a text message reminder system that is available through Odyssey Case Management System to track the appearance rates for defendants when it's tied to this FTA warrant. So the text message notification system does send texts to criminal defendants in advance of their court hearings, and I'll have a little bit more information about that. When we look at our ability to track failure to appear warrants, and in particular relative to the text messaging system, this is a display of how a court can select a failure to appear warrant on the Odyssey case. And then I'll show a report on the failure to, or the text message reminder program. So as I mentioned, Odyssey can send text message reminders to all criminal filings if a county is on Odyssey and the county has opted into the text messaging system. Odyssey will pull a phone number, a cell phone number, from either the Odyssey Case Management System or the supervised release system, which is our new case management system for community corrections and probation. And the system sends text message reminders 5 days in advance and 1 day in advance of the hearing. Participants can opt out of receiving text messages, but we do have data that can track when individuals receive or if they opt out of the text messaging notification. To date, we have 54 counties and 6 city and town courts who are currently using this feature, and the feature is tied to their use of the Odyssey case management system, and there is no cost to the county to use that. Because we have just improved our ability to track failure to appears, we will have a better ability to track what impact the use of this system is having on failure to appear rates. One of the things that we have heard significantly is a significant issue at the local level is concern not only about the jail population relative to failure to appear, which oftentimes when people are picked up on a failure to appear warrant, they are held pending the disposition of their case. But clearly it's a public safety issue. It's difficult, it's dangerous for law enforcement to go out serving these warrants. So we're hopeful that, like with other jurisdictions who have implemented this notification system, that we'll see a continued reduction in our failure to appear rates. So counties will be able to generate their own reports on the impact of their text message reminder system on their FTA rate. And then this will be a report that they will be able to run where they'll actually be able to calculate their appearance rate relative to the notifications and individuals who have received and accepted the notifications. Another initiative that the Department of Correction and Trial Court Technology have partnered on is the use of the supervised release system. The supervised release system was first built in Marion County a number of years ago, and it was built specifically for Marion County to manage their case management needs for probation and community corrections. The Department of Correction is now working with Trial Court Technology to deploy the supervised release system in all community corrections counties. And so we're working closely with Julie Lanham in DOC and Kristen Bonschbach in Community Corrections so that we can ensure that all community corrections and supervision agencies will have access to SRS. Deployment first will be to community corrections agencies by the end of 2020, and simultaneously Trial Court Technology is deploying this to probation departments and problem-solving courts and pretrial services agencies as resources are available. We expect ultimately that all community supervision agencies who wish to be using the SRS system will be able to use it. There is no charge to the county to use it. But the exciting thing about SRS is that it was built by Trial Court Technology in consultation with the Department of Correction. So it captures all of the data points that we know that we need to have so that we can begin to measure our outcomes relative to 1006 and the funding that was allocated for 1006, but also relative to our other programs. So we have a number of counties who are already using that. Deployments are continuing as we speak, and we are actually beginning to pull data from some of our SRS counties. So when we think about the jail data and we think about how complicated the issue is and how important it is to really delve down at the county level as well as have a sophisticated jail management system, there are a number of different scenarios for the task force to consider when we're looking at why an individual or how an individual is in jail that influence how long they may be there. So if we have individual 1 who's in county A's jail on a theft and they are released on bond, yet they get picked up in another county for a possession, County A revokes their bond, and then another county places an individual on a hold for failure to appear on a traffic offense. So at any given time, there could be individuals in our county jails who are being held on 3 separate holds, 3 separate counties, or possibly even more. And so I think it's important that we take a look at, in the future, the jail's ability to track those different types of holds so that we really have a handle on why individuals are there and length of stay for each individual hold. And another individual, they may be in jail for an offense for which they cannot pay bond, and they may remain in jail for the entire duration of their pretrial period up to the point of disposition. Another individual may be in jail for a battery offense. They post a bond or a $500 bond hasn't been paid. They also have a violation for community corrections in another county, and they're transported back and forth to another county due to jail capacity issues. And so movement between jails is something that's very difficult to track, as I understand it from talking with the sheriffs. in that when individuals are released on a hold, it's difficult and there's not consistency surrounding when individuals may be rebooked back into a jail and how they're rebooked back into a jail. And that, again, is another data issue that we would want to work toward addressing. And then finally, in another individual's case, they may be in County A on a failure to pay for child support, and then they have another warrant that's issued from another state while they're currently in jail, and that hold remains until they are finished serving their time on the child support warrant. So in my time working with the counties, particularly on the pretrial release project, the jail data issues, the reasons why people are in jail, the jail capacity issues are very complex. And so I think looking at these from, if we have the appropriate amount of data or the adequate data to look at this issue, looking at it on a county by county basis is probably going to be the most effective approach long term. So just to reiterate, since data is captured differently for different reasons, it's really difficult to compare reports. Sometimes when we try to pull information for the purpose of court and sentencing data, for example, and we want to be able to extrapolate that to different contexts and provide different information, but it's really difficult to do that. It can give us some indication of what may be happening, but we always need to look further. We always have a hierarchy of hold types so that when an individual is in custody for more than one thing, there is a hierarchy of why they are being held. So if they're being held on no bond for a certain case, no matter whether they satisfy child support or satisfy a bond in another case, or they're released on another sentence, they're always going to be held. So from a data perspective, we need to be able to distinguish between hold types. Assessment of the local jail population is critical to knowing who's in jail and what type of holds are associated with the population numbers. Length of stay is also very important to know how long someone is in relative to the intake rate or discharge rate from any particular jail. Some jails may be full but on a regular basis, but what is important to know is how many people are entering and how many people are exiting the jail and at what rate to really know what's happening within that county. And that viable solutions to the jail overcrowding issue will likely involve multifaceted approach that are heavily dependent on us having the data to be able to see what's happening and what our outcomes are. And I don't have any additional information if there are any questions.
Thank you. Questions? Ms. Corley?
Mary Kay, thank you for your presentation. You said on the texting that's available for counties and it's free of charge that 54 counties and 6 city and town courts are using it. Do you have any insight on why more counties are not taking advantage of this free service?
I think we may need to approach those counties and just encourage them to participate. Participation really doesn't require anything other than consent or permission from the courts to turn on the feature within Odyssey. So we could probably approach those counties to see if they would like to join the program.
Yes, sir. Thank you. Please.
Mary Kay, on pages 17 and 18, your categories that talk about individuals who had more pretrial credit time than sentence time, is that, can you say pretrial credit more than maximum sentence time?
More than the actual sentence that they were given at disposition.
The actual sentence.
Correct. So if an individual had 60 days pretrial credit but was given a 30-day executed sentence at the time of disposition, that's what that means.
Do we have any idea how many days that actually accounted for?
I don't, but I can check with Dave Williams and see if we can pull that number.
Well, there's almost 10,000 of those people who spent more time than they're needed to. Okay, thanks.
Please, Sheriff.
Thank you, Justice. Mary Kay, does the system in Odyssey identify or red flag the defendants who may be eligible to be one of those that is sent back to the DOC as an F6? And whose responsibility is that? I mean, does something pop up and say this particular defendant may be eligible for this at the prosecutor level with the judges? Are the sheriffs supposed to pay attention to that? Whose role is it to identify those candidates?
I don't believe that there is anything in Odyssey that would automatically flag those individuals. My sense would be is that it would normally be the prosecuting attorney's office that would advise the court of the individual's eligibility to return if that individual met that criteria on a violation.
Also, is there an effort at statewide or across the judiciary to sort of drill down on a definition of failure to appear? And you know, you might think, well, as long as your county gets it right, maybe it doesn't make a difference. But especially in the metro counties, we have a lot of other folks that we stop on traffic things, just like in your case examples, that might have this individual has a hold for failure to appear in another county. But not all of the courts, I don't think, have the same definition for what FTA is, right? For me, it might be a complete miss of the court. For someone else, it might be you're 32 seconds late, so you get charged with that.
Correct. I mean, there is judicial discretion in whether or not the court decides to issue a warrant based upon the information available to the judge at the time that the person fails to appear. So for the purposes of our pretrial project, for example, we do need consistency in how failure to appear is reported. We have defined that a failure to appear in the pretrial context for our outcomes as when a person fails to appear and the court determines that a warrant must be issued or the court issues a warrant. And we use that definition because we understand that there are times in which an individual does not appear, but the court has presented information and makes the determination to either give an attorney time to bring that individual to court or that there is a legitimate reason for them not appearing and they reset the hearing without issuing a warrant. And also because assuming the data is captured in the system for failure to appear, it is the most measurable indicator that we have of someone failing to appear.
Well, I can tell you the jails have a lot of those people.
Mm-hmm.
And if we could get the jail records managements or RMS to talk with Odyssey and those court systems, it would help because then the judges and the sheriffs and the jail commanders could see in real time where these individuals are sitting, if you will, because sometimes they might be in the Boone County Jail and miss court in Hendricks County and they get an FTA where if everybody had known they were sitting up in Mike's jail, perhaps they could have prevented that and lowered that number even still. So thank you for the focus on that part.
Steve?
Thank you, sir. Mary Kay, one question, and you probably don't know, but the portion of the FTAs that are due to body attachments and civil matters, do you have any idea of the breakdown?
I don't know that we do, no. I can check, but I don't know at this time.
Well, is the data capable of showing that?
I'll have to check with trial court technology and see if we can determine
Yeah,
that.
I don't think a lot of folks realize that some folks are in jail because they failed to show for a body attachment and got a pickup order on a failure to pay a bill, for example. So FTAs are complex, but it's good to know that we can track them.
I think Mary Kay has 1 or 2 minutes left, although I'm not the official timekeeper. Any other questions for Ms. Hudson? Thank you very much. Ladies and gentlemen, we will now hear public testimony. I have a list of people who have signed up to provide public comment, and I will state your name as best I can pronounce it, and I apologize in advance. Please come forward, speak into the microphone, otherwise you'll be like me, and if you turn any way to the left or right, you can't be heard. And may I remind you that you have 3 minutes. We do have a timekeeper, and so you will be given a 1-minute notice, and then you'll be advised when your time has expired, and please stop speaking at that time. Again, all of you, any of you watching can provide comments online, and you can supplement your comments today online. So with that said, again, we welcome your remarks and comments. And I would invite Mr. Sam Hobbs to the podium. Mr. Hobbs from Owen County. Or maybe it's more appropriately a sheriff or chief deputy sheriff. I can't tell from this far away, but welcome, sir. Sheriff.
Thank you. Sheriff Sam Hobbs from Owen County. First of all, I want to thank the good Lord for everything, his many blessings, and if anybody knows what we need, it's the good Lord himself. Thanks for the board members and staff. 2 things we missed out on so far I haven't heard today. I took an oath years ago to serve and protect the people of Owen County. The other 91 sheriffs took the same oath, and that's exactly what we're going to do. With that being said, we have a job not only as a sheriff, but as the rest of the officers here to get the bad people off the street. Sheriff Clark, I know exactly what I'm talking about, as the rest of Sheriff Nelson back here does. That's our duty. It's not our duty to facilitate those with mental health issues, addictions. Jails was never, ever established for that need. But if that's a need that we're gonna have to take on as sheriffs to administer health aid, mental illness treatments, opioid addiction, the funding has to be there. And that funding has to come far beyond the taxpayers of Owen County. We simply cannot afford it. I have 2 county council members here, the judges here, the probation officers here, and my administration staff is here. They have done well to help fund the programs, staffing additional officers, but I'll tell you, it's a far cry from what we need. So I'm asking the state, the feds, anybody that can come together. If you want us to help these people that are in my facility, we're going to have the funding to do it. Then, when do we quit letting them out of jail? They talk about, recidivism, so on and so forth. Pre-trial release, that's great for some people, 1%. 10% of the people might get some good out of it. Beyond that, it's not happening. The treatment needs to start before they get to jail. When they get to jail, they've always got an excuse why they want to keep reoffending. That's not my problem. It's not the taxpayer's problem. If Johnny and Mary make a bad decision, they need to learn from that bad decision. They need to rehabilitate themselves while they're living at homes, raising their families. It's not for us, as the sheriffs, or you or the taxpayers, to rehabilitate these people while they're at home. It's a choice they have to make. They need to start making the right choices. We cannot keep letting them in and out of the facility. It's not working. We need to find a better solution. Thank you.
Thank you, Sheriff. Ms. Liz Morris. Dearborn County Council, Association of Indiana Counties. Good afternoon, ma'am.
Good afternoon. Thank you very much. And as part of County Council, I would like to reiterate David Bardoff's comments about the DOC rate of reimbursement to counties as being a little bit on the low side. We would appreciate any consideration to have that reimbursement rate increased. But the main reason I'm here today is to talk about a program that our Superior Court 2 judge, Sally McLaughlin, instituted back in 2007. It's called the JCAP, Jail Chemical Addiction Program. When it first started, there was only room for, I think, 8 male inmates. There wasn't enough space in our jail to accommodate a female program. When we did a jail addition, it was done with the task force, and the consideration was given to have adequate space for the JCAP program to expand to at least 16 males and have a female class as well. So that was done, and there are statements from Indiana University showing that the success of the JCAP program has been demonstrated. The recidivism rate is lowered. The people have to apply to be part of the program, and their attorney also has to sign off on it. So it's an in-jail program to address their chemical addictions, and has been proven to be successful in Dearborn County. The judge who instituted the program happens to be an RN as well, and she has said that if her office can be of help to anyone who would be interested in doing a JCAP program in their county, she would welcome their comments or their questions. Her person who does the program is named Tisha Lindsay. The phone number for Superior Court 2 is 812-537-8800. And the program is staffed by masters, prepared counselors, so they're credentialed, and there's been a great deal of success. The judge has seen people outside of jail, and she didn't recognize them, and they thanked her personally for helping them get their lives back on track. So this is a great opportunity to take advantage of their time while they're incarcerated and get them on a successful track. It's not 100% successful like any of these programs are, but it has had a dramatic impact, and it does help them prepare for a better life outside of jail. Thank you for your time.
Thank you, ma'am. Mr. Ken Paust, Wayne County, sir.
Good afternoon, Judge David. It's indeed a pleasure to be here today. Briefly, I want to talk about mental health just a little bit. Recently, as a matter of fact, just 2 weeks ago, a task force was formed in Richmond, Indiana by our sheriff, and it was called Transport. And I was the commissioner that got assured the Transport Committee. Little did I realize what I was going to get into and how ill-informed I was about the mental health patients that we do have in our jail. As this task force goes forward, I'm going to learn a lot more, but when I heard you were here today, I made a quick telephone call and said, what are the important things you'd like for me to tell this commission here this afternoon? I think I can get it out real quick in my 3 minutes here. But basically, the mental health patient that we have in a jail, which is referred to a psychiatric ward, which we do have one in Richmond, Indiana, I found out there are some laws that they have 24 hours or a 23-hour stay period in which to evaluate that individual. If it goes in late in the evening, the next morning one of the doctors will evaluate that individual. That individual is either going to be sent back to the jail and held there after he has a consultation with a social worker and a plan that's put out by that social worker. Unfortunately, if he goes back with the plan from the social worker and he bails out, there's no follow-up on that mental program. So what happens, he goes back out, commits an offense again, and we find him right back in the jail again. At the same time, the other thing I found in a problem for the sheriffs in there is if the doctor says there's going to be a detention, that we have to go to the judge and we have to get a detention order for that judge. That usually would occur early in the afternoon, and in the process then, until the psych ward has that detention order from the judge, they can't call the sheriff to ask for a transport. In our case, we transport to Bloomington, Fort Wayne, Indianapolis, or Lafayette. And depending on that individual mental patient, that requires 1 or 2 sheriff's deputies to be able to transport that individual. As you read earlier today on some of the slides, we're all understaffed. That takes 2 people out. At the same time, when you get that call 2 or 3 o'clock in the afternoon, your shift's about ready to fail, or not fail, but to close out, and so you have to find 2 deputies, which means overtime. And in our case, our overtime budget is gone, and we have surrounding counties which send their inmates to us. And so this has become a real problem for us. And the social worker said, if I could emphasize to you, we are not funded, we don't have the programs, and to be able to handle those mental patients. You've closed most of the mental hospitals throughout the state. We had Richmond State Hospital in Richmond. Fortunately, through a spatial program, we do have 30 beds that are available in that particular area. Social workers said funding, the ability to follow up on these folks, that when you do send them back, that somebody follows them up after they leave the jail so they don't turn around, commit an offense, and come right back again. Thank you very much.
Thank you, Commissioner. Sue Ann Mitchell, Kosciuszko County. Ms. Mitchell.
Good afternoon, and thank you for the opportunity to speak justice and to the board. I am Sue Ann Mitchell, Kosciuszko County Council President, and I want to expand a little bit on what Liz Morris had shared on the JCAP program. The JCAP program came to our county through a grant from the Attorney General's office. We knew when we took it on it was not going to be free in the end. We knew that we were going to have to absorb some costs for it, but we think we have actually found a very productive program that we are hopeful will help to reduce the recidivism issues. We've had 3 classes so far, 2 women's classes and 1 men's class. Part of the problem is you have to segregate those people from the other jail population in order to make it be most effective. So that required a little bit of shifting in the jail. And we have found that this voluntary program, it does not affect their sentencing at all. This is a voluntary program that the board actually reviews, and determine who is qualified and who can be into this program. 20 hours of community service is a part of this requirement, so they have helped with maintaining, painting, cleaning, doing things in the jail, which has been a positive influence on trying to teach them some work ethic. Many volunteer groups have stepped forward, so at this point the county hasn't laid out a whole lot of cash other than we had a wonderful lady who was willing to volunteer her time in order to be the jail coordinator for this program. And the county took it upon ourselves to actually reward her by making her be an actual county employee because she has done such an amazing job at this. We have several volunteer groups that have come in, which has been an absolute blessing. We know that those aren't going to continue forever. We realize at some point those volunteer groups, like the Bowen Center, who has provided mental counseling, our Kosciuszko County Extension Office has provided Safe Serve certification so that those fellows and girls, when they get out, they conceivably could go into a restaurant setting and actually get a job. They've done smoking cessation, heart healthy programs. That's what our extension programs have done. We have a group called Bridge to Hope, and they have done great counseling events with those individuals, meeting not only individuals individually with them, but also as groups. We've had 2 banks that have come in and have done financial counseling. They've promoted violence prevention, parental classes, AA programs, the GED training. They did resume writing, and they had CEOs who actually who came in and did job interviews with these folks. People donated clothing, money for clothing, so they could actually be dressed as though they were doing a real interview. Faith-based living programs, physical fitness programs, and we are trying to track those positive results. And I just want you to know that Kosciuszko County is trying to do everything we can to provide some sense of accomplishment for those people so they take away a personal wealth that they'll be able to actually get a job and keep themselves straight in the narrow. Thank you so much.
Thank you, President Mitchell. Hendricks County Council Member Larry Hessen.
Justice David and members of the task force, appreciate the opportunity to speak here today. And what I would really like to do is to explain what we've done in Hendricks County to deal with the issue of jail overcrowding. For many years, Hendricks County has been faced with the specter of a federal court order for a new jail, and we've tried to stay one step ahead of that, and so far we've been successful. We started first with the dealing with those individuals who had already been convicted, and we were looking at options other than jail. Some of the county council members some years back pursued the idea of a work release center, and indeed we spearheaded the idea of a work release center, and were able to get a $4 million bond issue to build such a center. The idea behind that was to give the judges a sentencing alternative and to provide a resource that would permit those who had been convicted of maintaining employment, keeping their families supported, and contribute something toward the cost of their sentencing, their incarceration. That's been somewhat successful, but then came along the possibility of dealing with pretrial inmates, and we were one of 6 counties that were part of a pilot program, and Justice David has been deeply involved with that. It's the evidence-based decision-making strategy, and our team consisted and does consist of 6 judges and the court administrator, the sheriff, Sheriff Clark, the prosecutor, probation director, public defender, work release director, and a member of the Hendricks County Council. It's been slow going. We've taken baby steps. We've wanted to make sure that what we did not result in someone being released from custody and then going out and committing a serious crime, which would, in effect, kill the whole idea. Getting 6 judges to work together was a real challenge, as you might imagine. But through this process, protocols were developed, including a pretrial release screening protocol. And the council has funded 2 probation officers in order to do that screening. We first thought maybe the sheriff's deputies could do that in jail, or the jailers could do that, but they did not have access to the information necessary to develop the information that would permit us to do an adequate screening. It is working well at this point. We are building a jail, but so far it's been successful, and I hope that maybe our model might be helpful to other counties as far as pretrial release. And finally, I would say that the reimbursement rate from the state as far as keeping prisoners is not adequate. It may meet the expense of operations, that is food and so forth, but it does not take into account the capital expenditure, the cost of a bed. So it does need to be increased, and I hope perhaps in the not too distant future that will be realized. Thank you very much for your time.
Thank you, sir. Vanderburgh County Sheriff David Weddy.
Good afternoon. Thank you for having us out this afternoon. You know, we've talked about jail overcrowding, people in prison, seen a lot of bar codes and graphs. But let's talk about just the people. This year, Vanderburgh County has booked in over 8,000 people that were subject to a fresh arrest. We've released 7,200 of those same people, which means we've got a 90% rate of letting people out of jail quickly. That's an A rating. Most sheriffs don't want an A rating letting people out of jail. We owe it to the victims of crime to keep people in our custody. The average length of stay for somebody in my jail is 19 days. So if you want us to try to do programs, I don't think you're going to have much success in 19 days. If a person's in on a drug charge and they're pleading innocent, why would they enroll in a drug rehabilitation program? Wouldn't that imply that you're guilty? So they're not going to do it. We have a lady now who's probably defrauded or stolen over $100,000 from families. She's a funeral pre-planner and a grief counselor. And she takes money from people on the premise that they're planning a funeral with her. They think this may go into the hundreds of thousands of dollars in theft. And she's got arrested once by our agency. She was out within 2 days on a $500 bond. We've rearrested her on 3 more charges. We probably have another 6 or 8 charges, and she's out again. So that's just the way the courts seem to work. The premise that people are in jail because they can't afford bond is not typical in our jail. We have very few people that aren't subject to bond. And as Sheriff Hobbs stated, we have a duty to protect our community, and we put people in jail. And we keep talking about the nonviolent offender that's in jail. Most crimes are nonviolent in nature. Most people are arrested for crime, and it's not classified as a violent crime. Child molestation is not a violent crime, but it's certainly egregious, and we want people in jail. think we are years away before we can see crime trends drop. And in the meantime, we need jails that are adequate to house the proper number of people who are under arrest until the courts and the prosecutors dispose of their case. We owe it to the criminal to keep them safe. We owe it to staff to keep them safe as well. Our jail was built for a maximum capacity of 550 people. We've had nearly 900 people in our jail. I have over 200 housed out. So to us, the first priority is to build a jail so we can house our inmates. We've also found that many times when the offenders are released, they go out and commit additional crimes. It just happens. Many of our level 6 sentenced offenders have been charged with a level 5, 4, 3, or 2 felony, and they plead down to level 5, or excuse me, to level 6. They do the level 6 plead, so they serve half their sentence versus 75% of their sentence. The court clears their docket, and the prosecutor gets conviction, so they run for re-election. They got another conviction, even though it's a pled down. I don't have much time. I see I got my 1 minute thing, but I just wanted to say real quick. I had my jail commander pull up some statistics just randomly about people in our jail. He had 26 people. I've got number of arrests, 55, number of arrests, 62, number of arrests, 33, 37, 29, 35, 34, 33, 41, 46, 40, 47, 34 prior arrests. And one of them on the prior arrest, robbery multiple times, robbery strong arm, robbery with firearm, possession of paraphernalia, theft, trespass, domestic battery. Another one, attempted murder with knife, serious bodily injury, battery aggravated with deadly weapon, battery domestic multiple times, battery on law enforcement, resisting law enforcement, robbery, strong arm, intimidation, invasion of privacy. Another one that was in 29 times, murder, 2 separate cases, 3 victims, carjacking, possessing firearms by a felon, robbery with firearm, resisting law enforcement multiple times, auto theft, battery with injury, battery, law enforcement with injury, battery multiple times, dealing marijuana, criminal recklessness. So the people we have in jail, they're not a person who just accidentally came in and we're holding them egregiously. These are people that need to be in our custody. And also, jails
Sheriff?
are not corrections.
I need you
Yes.
to wrap it up, sir.
Yes, okay. Well, I'm just saying, we talk about who's in jail, and we need to talk about why and who's in jail, and jails are not correction, that they are detention facilities. And when we start putting level 6 felons, I've got 170 level 6 felons in my custody, and we're not being paid for it. Thank you.
Thanks, Sheriff. Boone County Sheriff Mike Nielsen.
Good afternoon, ladies and gentlemen of the committee. Thanks for having us today, and thank you for doing what you do. I know it's a crazy task and very hard, but it's very much appreciated from us out here. I am passionate about what I do, just like all other 91 sheriffs in this great state. A huge part of that passion is rehabilitation of those that are in my jail, that are suffering from this disease, and it is a disease, by the way, called addiction, and the chronic mental health folks that are placed in our jails on a daily basis. Remember, mental health and addiction are intertwined. It's a fact, and it's medically proven. I'm here today, however, to speak to you about the public safety lit distribution funds, because I can speak about jail and incarceration and rehabilitation for many, many hours. My good friend, Elise Nacella, who is our Boone County Council Vice President, will be speaking to you next. And we want to talk about an issue that many of you probably do not know about. Let me just kind of lay the groundwork for Elise. Boone County implemented our public safety local income tax in 2016. That's when we had the push for it. In 2017, they passed our tax unanimously by all taxing authorities in the county. And what I can tell you is that that tax took effect in 2017. Annexation of communities will continue in all 92 counties in Indiana. And annexation is good, but it's also bad when it comes to the public safety lit distribution. Both annexation and reorganization cause issues with the public safety lit distribution. Neither of these provide funding to the counties to support the back end of what happens when the municipal law enforcement agencies make an arrest. Every municipal agency in our county hired many new law enforcement officers after the passing of our lit tax. 40 new officers in Boone County. What happens with 40 new officers? Arrests go up. So what I can tell you is they put them on the road in early 2017 and 2018, and now we are seeing the issues that this has created. You can call it an issue, we call it safety, and we took that very seriously in Boone County. So we are now seeing the results of this in the county in many different areas. The jail, the overcrowding is one of those. I can tell you the court system docket, the prosecutor's office having to pursue more cases. None of these issues with the PS Lit distribution deal with those back-end expenses. The other concern with reorganization is the fact that the urban area versus the rural area in our situation in a town that we have is set by an MOU between the county and that municipality. Typically, a municipality will address services in urban areas and the county will address services in the rural areas. In our situation, a town has 26,000 residents. Let's say it's a split of 50-50 as the population. The PS Lit revenue, all 26,000 residents go to the municipality and none of that goes to the county. At the same time, the sheriff's office and the county highway support the area of 13,000 people. This needs to be accomplished with better MOUs or legislation that looks at that distribution of funds. In closing, I only bring this up because we all need to attack this problem and deal with this problem as we move forward with reorganization versus annexation. So as I close, I want to say that we are all need to work on fixing our overcrowding issues. I also want to thank each of you for this daunting task of resolving this jail overcrowding issue. It takes a village to get the resolution to a problem as difficult as this one. We can't continue to do traditional jails as we have known them, thinking outside the box with more in-house mental health services, medical assisted treatment programs, transitional housing, and continuity of care should be some of those things that we focus on while continuing the programs that we currently have. You can ask any sheriff in this room, we fail our inmates when they walk out our doors. We simply have to do better. Thank you for your time today. Elise?
Thank you, Sheriff. And trust me when I say, A, I didn't know they were going to be here, and B, they signed up one right after another to speak. So they choreographed this well. Elise?
Thank you, Justice David and members of the task force. I would only like to add to Sheriff Nielsen's very thorough comments an example for you on how we need consideration for a new formula that takes into account the added fiscal impact of these responsibilities that we have, duties that we have as a county, from funding the courts to the jail, from the prosecutor's office to probation, from community corrections to countywide emergency communications. So the example is this. There is a town in our county that receives the same amount of funding from public safety local income tax dollars as we do as a county, and we have these extra duties as well. So would appreciate your consideration of this issue. Thank you.
Thank you, ma'am. Mr. McKnight, you were kind enough to recognize earlier when we had that 30-minute, and then you were gentleman enough to sign up to come back. So we owe you your 3 minutes, sir.
Wow, well, thank you. What I was talking about before is really what's a perfect storm of factors, some of which appear to be unrelated, but they're all coming together to create a situation in which the liability of people, the counties and the people who operate their jails has never been higher, and the number of cases that are being brought have been very substantially increased, more than we've ever seen in the last 4 years. So what we have found is some of these factors, maybe we'll get there. Okay, thank you. Some of these factors are are difficult. Some of them are almost comical except for their seriousness. When I last spoke, I was talking about gender issues, and it has not yet been resolved by the federal courts as to what do you do with a person who's born one gender, and when they get to come to your jail, they say, I want to be treated because today I'm feeling like I'm the other gender. About all the courts have decided, from what I can tell, is that if anything goes wrong, for instance, if you take a female who now believes that he is a male and put her in a male population and things go wrong, it's your fault. That requires more segregation facilities. Current jails, especially older jails, do not have enough segregation facilities to deal with those kinds of social issues. The number we've already established, the number of pretrial detainees has gone up across the nation. Indiana, the number is 56% of the jail population. We'll get to why that's critical in a moment. The opioid crisis has increased the number of people. They increase the number of people who come in with significant medical and psychological needs. It also increases the number of people who come in with self-destructive behavior, either addiction and or suicidal ideation. It increases the risk of contraband coming into the jails too, and the need too for specialized medical treatment, which the courts are increasingly beginning to hold local governments liable when somebody comes into the jail and is taken off, say, a program designed to break their addiction, or they come in just plain addicted and they have to go cold turkey. Some courts have found that to be cruel and unusual punishment. Suicidal self-harm trends are way up across the country. If you look at the number of people, the age-specific mortality rate, it spiked in the period in which the opioid crisis also spiked. And what's really significant is the biggest part of the spike is people that are prime prison age. In Indiana, has not been any exception. We see that in the last 18 years, the number of people who have died as a result of accidental poisoning or intentional self-harm has gone up 350%. You can expect that if that's what's happening in society in general, that same ratio, or maybe even greater, is going to show up in your jails. Now, here's where it all comes together. All these things come together and get really ugly. There has been changes in the law which substantially lower the threshold that somebody has to reach in order to prove liability of the jailer for mistreating prisoners. That has led to a major increase in the frequency and cost of lawsuits and an increased exposure to federal court intervention. The cases that we're seeing mount with increasing frequency is failure to provide adequate medical, mental, and dental treatment. It may be that jails aren't well equipped to do it, but the courts are beginning to find that in certain circumstances, it is becoming your duty. And this would failure to provide adequate physical security to protect against inmate attacks and rapes, theft of prisoner property, dangerous contraband, and inmate weapons. That is increasingly difficult when you have the people packed into jails in an overcrowded position. I was curious myself, so I looked up in the internet how much fentanyl is necessary to kill someone. And it's extraordinarily small amount. And yet our jails are processing people in and out of the jails, and that tiny little bit of fentanyl is enough to kill someone. And we're finding in jails that that in fact is happening. The task of the jailer to try to prevent that from happening is getting increasingly difficult as more potent illegal drugs come on the market. Failure to provide adequate living conditions is another big one. maybe the liability isn't going to be as great, but the frequency that this litigation is brought is gone up substantially. As an example, we're involved with a county that has until recently has not been in an overcrowded position. It has a great sheriff. It has a very conscientious jail staff. And in the last 2 months, they've had more litigation filed against them by prisoners on a pro se basis than they've had in the last 5-10 years. Some things that we would suggest be considered by this group. First of all, and you're doing it now, but to continue to favor strategy that avoids incarcerating people who don't need to be in jail. And we certainly are encouraging all the counties that we're involved with to fully embrace not only the letter, but the spirit of evidence-based risk assessment program. Create effective alternatives to jail. I think the previous sheriff was exactly right that the number of days that people stay in jails is short enough that to have an effective program other than just to get people signed up and interested in the program is unlikely to happen in jails because they don't stay around long enough. But things like veterans court, drug court, electronic monitoring and work release programs are also ways in which the jail population might be diverted into more constructive places for people who otherwise would be prisoners. Reduce recidivism, change the behaviors that lead to rearrest, chemical dependency and addiction classes, anger management classes, alcohol and narcotics anonymous classes, and then again, it was previously, we said you can just barely get these people started, maybe get them interested in programs or at least aware that the programs exist, but there has to be a handoff to community services because they aren't in the custody of the sheriff long enough to have an effective, have these programs have a lot of effect. Now to be sure, renovated, expanded, and new jail facilities are needed, but another consideration is please consider expanding the amount of revenue from the new jail income tax option that can be spent on operations and programming, especially for staffing. Each county's needs are different. We would suggest that you reconsider the pro-construction bias and allow counties more flexibility in how, when, and where they apply this new revenue. This seems to be the only beginning. We would suspect that this situation is going to get worse before it gets better. The reduction in the threshold of the liability attaches to prisoners is very significant, and it's going to be very costly if it's not, if these things are not addressed. Thank you.
Thank you very much. Any questions from the task force to Mr. McKnight or Mr. Bauer? Anything? Bernice?
I have one for David Bauer.
One for David?
Yeah. Thank you, Justice David. While you're coming, David, you mentioned in your testimony that 1006 needed to have a phase 2. And as you expounded on that, you seem to be suggesting that phase 2 needed to include funding for services in counties. So my question is two-part. What do you see as a whole phase 2 that's needed for 1006? And if I'm correct that services are part of it, if services are funded in counties, do you believe that judges and prosecutors and other stakeholders will use those service alternatives as opposed to putting people in jail?
I mean, it's hard for me to predict, what judges would want to do, but I think hopefully if they feel more comfortable that there's programs available for people who need these services, that they'd be more willing to do it, community corrections, work release, sort of, I can't say sentence them to a drug rehabilitation facility, but somehow make sure that they do attend classes and get those kind of treatments outside of the jail, because as mentioned earlier by the sheriffs, the jails aren't really set up to be treatment centers. so they can only do so much with the population they have in the jail. But this handoff is going to be critical. Again, I think the other part of the phase two is to kind of look at the sentencing again, and it's been mentioned before by others, make sure we don't have people coming into the jail who really aren't a risk to themselves or others, and that takes another review perhaps, or the consistent review that happens on sentencing and the violations that are in statute, and what happens to those people. So, but again, I think other states who've gone through this process, they've all had to continue to evolve. I call it the phase two. I think we're just in that position now where we have to do that in Indiana.
Thank you. Any other questions? Thank you, gentlemen. In just a moment, we'll hear closing comments from Mr. Tracy Brown, Tippecanoe County Commissioner, and AIC's representative on this task force. First of all, on behalf of the task force, thank you for being here. Thank you for your testimony, your presentation, your comments. Keep those comments coming. You have the website. You have access to the website. Our next meeting will be October 30th. Details of the exact location up north will be available on the website very quickly. So October 30th is the next meeting. November 6th is the third meeting. Thanks again for your willingness to be present and for your comments. Mr. Brown.
Good afternoon, everyone, and thank you, Your Honor. I want to, as Justice David just said, I want to thank everyone for being here today. Believe me, I hear the passion in your voices, those of you in county government and my brother sheriffs out there. You're in a tough place right now. It is also important that we thank the members of the Indiana General Assembly who brought us here, Representative Sturwald, Representative Fry. We do appreciate that. We've got a lot of work ahead of us, but for their work, we wouldn't be having this discussion today. I want to draw your attention to one of my favorite movies from a few years, and some of it I may date myself just a bit with this, but you may recall a line in the movie Field of Dreams where Kevin Costner's character, Ray Kinsella, heard a voice in the middle of the night. And it was a simple message. If you build it, he will come. My former sheriff, Dave Murtaugh, said it in a different way. He said, if you build it, they will come. And he was talking about jails. And in Tippecanoe County, we have certainly seen that over the last 3 decades. We built a brand new jail at 2640 Duncan Road that was initially constructed to house 72 inmates. And roughly a month before we got our occupancy permit, we went in and we welded up another 72 bunks, basically doubled the size of the facility. And within a decade, just a little over a decade, that facility had grown from 144 beds to 553. And now we find ourselves having this conversation about the possibility of adding on to our current jail facility by building another pod, or heaven forbid, the possibility of constructing an entirely new jail. I can tell you that cost is going to be much more than the nearly $30 million that we spent years ago to build and renovate a jail. This discussion that we're having as a task force is a timely discussion, not only for Tippecanoe County, but in looking at Executive Director Lewis's presentation earlier. By my calculations, and I'm not really good at math, but it looked to me, Steve, like at least 1/3 of Indiana's jails were in crisis right now, with more people in jail than they physically have room for. And we know what happens as a result of that. Your litigations and your risk is magnified immensely. Justice David, earlier you said something that could easily become the mantra of this task force, and I'll quote you: we must have the right people in jail for the right reasons and the right amount of time. You are absolutely spot on. We need jails. There are people out there that we don't want in public. They pose a risk, an unbelievable risk. They need to be locked up. They need to be sent to prison. But there is a percentage out there that there are other ways. And I have to wonder if we knew today, or knew 20 or 30 years ago, what we know today about recidivism rates and addictions and other things that we are just scratching the surface on, we might be in a different position. We have a great deal of work ahead of us, and that work begins with real conversations just like this. And I was very encouraged to hear Executive Director Lewis talk about real-time jail data, because we haven't got that right in Indiana just yet. And at the root of any solution that we may be looking for out there, we have to have those data points. So again, our work isn't done. We've got much to do, and we'll do that collectively. And we need your help, we need your input, we need your thoughts, your ideas. Thank you again to everyone who took the time out of your day to be here with us, to our task force members, and to our many presenters. Justice Dave.
Thank you, Mr. Brown. Thank you to our Chief Justice. Thank you to our co-chairs, Representative Sturwald and Senator Gaskell. Thank you to the task force members, and most importantly, thank you for being here and participating in this process. We will adjourn into an executive session.